start?
Okay, I think we can go ahead and get started. First off, I want to thank UCLA and the Critical Race Studies program for having this wonderful event on intersectionality. Just to speak to the importance that theory can have in a person's life, intersectionality is why I went to law school. Some of this work was being written while I was in college, and I found it incredibly inspirational and an entirely new perspective, and made me feel like I could make a real difference in the world. And it's continued to inform my scholarship in the years since college and through law school and the start of my career. And so I just want to sort of testify to the importance of intersectionality to myself and how much of an enriching impact it's had on my work and on the people I've interacted with. So the panel for today is called Intersectionality in the Courts, and the purpose of our discussion is to highlight the insights that intersectionality can provide to different actors in the court system. And that includes litigants, judges. What are the ways in which intersectionality can enrich our understanding of the legal disputes being adjudicated? So what we'll talk about are the practices of judicial decision-making, the way anti-discrimination doctrine itself is formulated, how intersectionality can make important insights and interventions in terms of the formulation of doctrine, as well as the narratives that courts create that really are at the heart of some of these intersectionality cases, because unless the narratives accurately give voice to the various intersections of difference that play a role in the discrimination, much of the important information is lost before we ever get to the precise doctrinal question. And finally, we'll consider how these narratives play a role in individuals' understandings of their own identities and their willingness to participate in political movements. So this panel is sponsored by the American Constitution Society for Law and Policy. Most of you are probably familiar with ACS, but for those of you who aren't, it's a national network of lawyers, law students, policymakers, and judges who are dedicated to promoting the vitality of the U.S. Constitution and the fundamental values it expresses. And specifically, it concentrates on questions of individual rights and liberties, how to define genuine equality, access to justice, democracy, and ensure observance of the rule of law. So I'll briefly introduce you to the members of the panel. Each of them will have about 8 to 10 minutes to speak. And then we'll have a period for question and answer. And we'll start that off by engaging the members of the panel and exploring some of the issues that they've introduced in their presentations. And then I'll take questions from the audience. So our first presenter for today is Professor Cheryl Harris. And she is the Rosalind Arthur Gilbert Professor of Civil Liberties and Civil Rights at the UCLA School of Law. She teaches constitutional law, civil rights, employment discrimination, critical race theory, and race-conscious remedies. She began her career working at one of Chicago's leading criminal defense firms, and she also served as a senior legal advisor in the city attorney's office during Mayor Harold Washington's administration. And she worked on major reform efforts during that period. She has also served for several years as the national co-chair of the National Conference of Black Lawyers, and during her tenure she's developed expertise on international human rights, in particular issues arising in South Africa. She's actually helped facilitate and organize several major conferences that helped to establish a dialogue between United States legal scholars and South African lawyers during the development of South Africa's first democratic constitution. Professor Harris's work, again, personal testimony, has been extremely important to me, but one of her most seminal pieces is Whiteness as Property, which was published in the Harvard Law Review, and her scholarship since that time has also taken up issues such as Hurricane Katrina and issues of representation in representing that particular tragedy, as well as more recently she's taken up questions of how race functions in an officially colorblind terrain. And she's authored a piece with Devin Corbato called The New Racial Preferences that I highly recommend people pick up and read. It's really quite fascinating. Professor Harris is also a consultant to the MacArthur Foundation, and she is a recipient of the ACLU Foundation of Southern California's Distinguished Professor Award for Civil Rights Education. Our next panelist is Julie Su. She is litigation director for the Asian Pacific American Legal Center for Southern California, which is an affiliate of the Washington, D.C.-based Asian American Justice Center. She's also a senior fellow of the Jamestown Project, and she was one of the leaders in fighting for the freedom of Thai garment workers who were enslaved for years in an apartment complex in El Monte, California. She served as lead counsel in a federal lawsuit against the garment manufacturers and retailers that these garment workers were sewing clothing for. She was one of 6 national leaders to appear on the Smithsonian National Museum of American History's exhibit on sweatshops, and she is a co-founder of Sweatshop Watch. Ms. Sue also litigates to end discrimination in the workplace and education. She has represented Asian Americans, African Americans, and Latinos in cases ranging from challenges to UC Berkeley's admissions policies to Abercrombie & Fitch's hiring practices. Mrs. Sue was also awarded a MacArthur Genius Fellowship and received the 1996 Reebok International Human Rights Award. In 2005, the Daily Journal named her as one of the top 75 women litigators in California, and she has been recognized on programs like the PBS show Personal Best, as well as featured in national magazines such as The American Lawyer and Biography magazine. Ms. Sue's publications include Making the Invisible Visible, The Garment Industry's Dirty Laundry, which was published in the University of Iowa Journal on Gender, Race, and Justice, as well as Critical Coalitions with Eric Yamamoto and Critical Race Theory, an anthology. And our last presenter for today, I'm sorry for the long introductions, but there was so much that was wonderful about our presenters that it was very hard for me to leave things out. So our last presenter is Professor Paul Butler, who's Associate Dean for Faculty Development and the Carville Dickinson Benson Research Professor of Law at George Washington University School of Law. He teaches in the areas of criminal law, race relations law, and jurisprudence. Professor Butler formerly worked as a special prosecutor on public corruption cases, and he's also worked as an assistant U.S. attorney prosecuting gun and drug crimes. His unique experiences have allowed him to publish many substantial pieces offering insightful critique of the criminal justice system and judicial decision-making. And his work has made him one of the most frequently consulted scholars on issues of race and the criminal justice system. In particular, his scholarship has been profiled in 60 Minutes, Nightline, the evening news broadcasts on ABC, CBS, and NBC, and he was recently awarded the Soros Justice Fellowship. He's also a member of the American Law Institute and regularly delivers lectures to the NAACP and the ABA. Pieces include Much Respect Toward a Hip-Hop Theory of Justice, which was published in the Stanford Law Review, Racially Based Jury Nullification, Black Power in the Criminal Justice System in the Yale Law Review, and When Judges Lie in the Minnesota Law Review.
And 3 articles in the UCLA Law Review.
He recently published a book called Let's Get Free, A Hip-Hop Theory of Justice. Okay, so before going on to our panelists' presentations, I just wanted to say a few words about intersectionality to set the stage for our discussion and provide a framework for our conversation. Back in 1989, more than 20 years ago, Kim Crenshaw's piece, Demarginalizing the Intersection of Race and Sex, laid out a critical problematic that faces anti-discrimination scholars, judges, and anti-discrimination activists. And this problematic is something that we continue to wrestle with to this day. And what she pointed to was a tendency to treat discrimination along a single vector of difference, for people to view race discrimination as kind of a homogenous experience, or talk about sex discrimination as though all people experiencing sex discrimination experienced it similarly. And she challenged us to think about the limitations of this unidimensional approach, and she did it in a way that I found particularly compelling, which was she showed how it played out in terms of Title VII workplace anti-discrimination doctrine, showing how black women plaintiffs who were allowed to actually give full voice to their difference were then accused of not being representative of women as a group or of blacks as a group. And so in their attempts to sort of represent their specific experience, they were denied the ability to advocate on behalf of others. And she also talked about circumstances in which black women allowed that difference to sort of be contained in some way so that they could serve as representatives, talking either about race or sex discrimination, and about the conceptual losses that occurred because of that strategic decision to sort of step back and allow one vector of difference to be emphasized. And she wondered about the theoretical nuances in discrimination that we were missing as a consequence of black women being required to sort of take this step back and use one of the existing race discrimination or gender discrimination categories to represent their claims. In her first piece, she emphasize three themes that I think are going to come up today in the presentations from our speakers. One of those most important themes is that when we focus on race discrimination or gender discrimination in the abstract, without understanding the ways in which both kinds of discrimination interact with and shape the experience of race and gender, we tend to privilege the experience of people who are the most powerful in that group. So when we talk about blackness without talking about gender, we tend to privilege the experiences of black men. And what are the consequences of that kind of privileging? And I think that this issue is going to come up in Professor Butler's presentation when he talks about domestic violence and the Rihanna and Chris Brown case, the extent to which Rihanna's special circumstances are able to be fully represented if we talk about the racism of the criminal justice system or the racism in which questions of domestic violence get interpreted. The second theme from Crenshaw's work was the tendency to under-theorize the experience of discrimination suffered by the diverse range of persons within each category. So again, this is going back to the question of missing out on the nuances, the special things that black women have to teach us about how different kinds of invidious discrimination can work together to create someone's experience. What are we missing out on in learning how discrimination works by ignoring these groups? And I think to the extent Professor Harris's presentation is going to focus on questions about how particular aspects of difference get culled out of discrimination claims in order to make them simpler for courts to interpret, she'll be touching on some of those questions about missing opportunities to theorize about how discrimination works. And then I think Professor Su's presentation is going to touch on the last major theme, which I thought was the ways in which judicial decisions can affect our ability to politically mobilize, the way they represent different groups' interests in remedying discrimination or addressing discrimination, treating them as these kind of autonomous and independent groups rather than recognizing the linkages between discriminations. She's going to talk about the intersectional insights generated for judges if they take advantage of their various identity vectors and how they can shape one's perspective. If judges de-emphasize certain aspects of difference and choose not to focus on that in their decisions, how do the decisions they produce then affect the communities to which they're intended to speak? So with that, I will turn things over to our first panelist, Professor Harris.
Thank you, Camille. Let's see here. Good morning. Welcome. Thank you very much for coming. It's a great honor to be here to share the podium with Paul and with Julie and with Camille. And it's a great honor to start this conversation thinking about the thematic that's occupying us for this weekend in the context of the courts. So the story I want to talk about today is a story that might be characterized as a case of lost and found intersectionality, or maybe lost and lost intersectionality, or maybe even lost and found and lost. You can decide at the end. But I want to talk about Ricci versus DiStefano, the New Haven firefighter department case that came down in the Supreme Court last term, and its interface and interaction with the nomination of Justice Sonia Sotomayor to the Supreme Court. So the summer that the case came down was very hot in D.C. It usually is hot in D.C. in the summer. There's no, Paul, you can attest to that, I'm sure. But it wasn't just hot because of the weather. It was hot because of what was going on in the Judiciary Committee, which was conducting hearings on the nomination of Judge Sotomayor. And if you recall, the candidate had been put forward as Obama's first nominee, and it seemed that at that moment her experience, her life experience, her intelligence, her rigor, and her empathy were touted as reasons to recognize this as a stellar nomination. And implicit, if not explicit, in the very happy faces that surrounded that initial press conference was the fact that the nomination represented the first time a Latino was going to be appointed to the bench. That is, this was a representational moment, right? A moment in which the country's diversity could be marked and celebrated. The fact that she was a Latina, that is both a woman and a member of a subordinated racial group, was quite interesting because in that moment she actually got to stand for and represent that group. The fact that she was a woman did not disable her from representing her race. This, however, contradicts what we know to be the traditional dynamics, and indeed the dynamics that Kim Crenshaw's piece illuminated, as Camille indicated before. What Crenshaw's work exposed in demarginalizing the intersection of race and sex is a critique of anti-discrimination laws' disallowance of the employment discriminations of claims of black women as black women. But there was also another part of the critique which talked about the ways in which black women were disallowed from serving as class representatives in class action suits involving race and sex discrimination actions. Thus, their claims were not only invisible, but they were not cognizable within the structures of anti-discrimination law. They were not deemed to be able to represent all women in sex discrimination claims, nor were they able to represent all blacks in race discrimination claims. So what was interesting about this moment of the Sotomayor nomination was, one could say, it was a found intersectional moment in the sense that she was able to represent her race as a woman. Right? Despite all the initial celebration, however, we know that it proved to be short-lived, and in part, two lines of attack emerged, and in important ways mirrored each other. The first pertained to Sotomayor's ruling in the Ricci versus DiStefano case, and I won't go over the case at length now except to say the city of New Haven, like most urban fire departments, had a long history of racial exclusion. At the entry level, blacks were about 32% of the entry-level firefighters, and that had been after 20 years of fighting and suing in court, and there were only 15% of the supervisory positions. So when the city gave a test for new promotional positions, it produced wildly racially disparate results, meaning that had they made promotions based on the test, no blacks would have been promoted, and only one or two Latinos. So the city canceled the test out of concern that it was going to face disparate impact liability. That is, it would be sued under Title VII for using a facially neutral assessment tool, but one which produced a racially disparate impact. The problem was the city's lawyers told it that it could not show that there were not less discriminatory alternatives available. So everybody was going to get a redo. Ricci, however, and the 19 other firefighters challenged the city's action as unlawful disparate treatment discrimination. And Sotomayor's ruling on behalf of the city, that is upholding the city's decision, was challenged as evidence that her identity, that is as a Latina, trumped her willingness to adhere to the law. It was evidence of her bias. And there was a particular specificity of stereotypes regarding Latinas that were evoked in that story. I mean, some of the story was, some of the attacks were in the more sort of quote-unquote civil register. Others actually mobilized these images in the course of attacking her, and I won't, reiterate them, but you remember some of the pictures in which she was portrayed in a Mexican hat, some of which actually collapsed sort of cultural symbols and, had her as a Puerto Rican in Mexican garb. I mean, the whole thing. Of course, Ricci's identity did not do similar work. That is to say, his identity as a white male, a class that had benefited from the existing distribution of power and resources, did not call into question his commitments to fairness or whether his perspective on what was fair was right. But in any event, this critique of Sotomayor as a Latina whose identity was trumping her ability to be fair converged with the dredging up of her now infamous comment in which she invoked her own identity at the intersection of race and gender, where she said, "I would hope that a wise Latina woman with the richness of her experience would more often than not reach a better conclusion than a white male who hasn't lived that life." So as the crescendo of criticism swelled, Obama walked that remark back for her saying, I'm sure she would have restated it. Whether she intended to restate it or not, he certainly walked it back for her. So there was a very clear signal there about how she was to proceed. So the very life experience that had been so valued at the beginning, that life experience at the intersection of fighting both gender and race discrimination that shaped and influenced and affected viewpoint, that same set of experiences that is sometimes invoked by the likes of Clarence Thomas when he engages in talks around the country became something to be disavowed. And so in that moment, the intersectional position became an albatross. The second piece of what I want to say, and I'll have to say it relatively quickly, but I could be happy to expand when we go forward, is what might be called invisible intersections. So, or the lost ones. One of the things that's very fascinating when you look, my colleague Kim West-Falcon at Loyola Law School and I have just co-authored a piece on Ricci. And one of the things that's very interesting is when you dig down into the statistics, the racial disparities are remarkable, but the gender disparities are off the chain. And in that regard, there's a Slate article on the New Haven Fire Department, which speaks of one Erica Bogan, African-American woman. She is one of 11 female firefighters in the entire city. Okay? So one of the things that's quite interesting about thinking about the framing of this case and who got to represent the racial discrimination claim. It's clear that this case was in an unusual posture in that the potential plaintiffs were not actual plaintiffs. That is, the people who were affected by the racial disparities of the test were not plaintiffs in a disparate impact suit. But one of the things that Kim and I do in our piece is we try to imagine what that lawsuit would look like. Right? In opposition to Ricci's disparate treatment suit, we try to imagine what would the disparate impact suit look like. And we roll it out in relatively traditional forms, and here's where I'm offering a critique of what we did. Because what I'm saying about the invisible intersection is if we had imagined Erica Bogan as the lead plaintiff and representative of the class in that lawsuit, what might have we seen? Well, what might we have seen is not just the disparities that were visible through the lens of race, but disparities visible through the lens of race and gender. That is, if we look at the percentage of black men as firefighters in the New Haven Fire Department, it's roughly 32%. That actually roughly tracks the percentage of blacks in the city of New Haven. But if we look at the question through a more intersectional dynamic, at the question of Erica Bogan, right? The disparities are, as I say, off the chain, right? One of the reasons that this is important, and there's a history to this, how many minutes I got? Am I over? Okay, I'm over. All right, let me wrap it up, as Chappelle would say. So one of the things that's very interesting in the history of looking at the history of Title VII is I went back and looked at the testimony that was given before the committees at the time of the amendments of the Civil Rights Act of 1991. And these were the amendments that were put in place to correct the train wrecks that the Supreme Court had created in the 1989 term, among which was Ward's Cove, which was a case that basically screwed up disparate impact law. We can talk about how it screwed it up. And essentially what you had was Congress trying to fix that. Some of the main testimony that came before the committee that was actually quite powerful was testimony from a woman by the name of Brenda Berkman, who was a New York City firefighter. And in this testimony, she talks about what she and her colleague, a woman by the name of Zeta Gonzalez, faced when they tried to essentially become members of the New York City Fire Department, how the physical tests were used to exclude women, ultimately how the judge ruled in their favor, and despite that, these women were sexually harassed, intimidated, and fired, and had to sue once again to get their jobs back. The point of all of this is to say that what becomes visible is a bigger window that helps us understand the interlocking nature of these forms of subordination, and I'll close with this by bringing it home. So here in Los Angeles, there's a case Brenda Lee versus the City of LA. She's a black lesbian firefighter who sued on the basis of race, gender, and sexual orientation. She won a $6 million judgment for the harassment that was done to her, and a California Court of Appeals has just overturned that jury decision. One of the things that I think is important about Brenda Lee's story is it gives us an opportunity to tell about those invisible intersections that ultimately help make it all make sense. Make sense in the way that our fighting on all of these fronts is key to the broader sort of question of eliminating discrimination. Thank you.
Okay, so I think it's amazing to be speaking on a panel with one of the most esteemed professors in the country who quotes Chappelle in a lecture. But much has been written about whether the identity of judges affect their decisions in cases. And as Professor Harris has talked about, the Justice Sotomayor lead up to her confirmation really gave us all a front row seat to that debate. And I think that what was most problematic to folks who were critical of Judge Sotomayor's nomination and her comment in particular was not so much or not only that she made identity and racial identity extremely important, but that she actually said that that would make someone better than a white man. There have been two recent studies that actually conclude that the identity of the judge, the racial or gender identity of the judge, has an impact on the outcomes of cases when the subject of the case is race or gender. And so in one of those studies that looked at racial harassment in the workplace cases, the plaintiff was much less likely to lose if they had an African American judge versus a white judge or even an Asian American or Latino judge. And in a separate study, it showed that in sexual harassment or sex discrimination cases, an appellant was much more likely to win, at least twice as likely to win, if there was a woman judge on the judge's panel. But those studies also know, as critical race theory makes clear to us, that it is exceedingly difficult to isolate any one aspect of identity, either the judges or the parties, in making such conclusions. However, I think that they are interesting to note since they looked at cases, thousands and thousands of cases. I want to speak as a civil rights practitioner about how intersectionality affects the experience and perspectives of litigants when we go to court, and how the courts allow or don't allow us to bring the multiple aspects of our identity into the courtroom. And I want to focus not on the cases that I have worked on that are explicitly about race, not about cases that have to do with employment discrimination on the basis of race or on access to higher education for kids of color. What I want to talk about are cases in which the issue or the dispute is not explicitly about race. And I'm going to use two examples. The first is in the sweatshop worker context. So to put a little bit of context to that, sweatshop workers are almost entirely Asian and Latina, overwhelmingly women, but also men who work in factories, often side by side. And their direct employer is often also Asian. So it's an Asian factory owner or sweatshop operator who often fans the flames of racial distrust between the workers in order to maximize their ability to control the workers. So one of the attacks on our organization, on many of us, my colleagues who are here who do this work, as Asian Americans who advocate for Asian and Latino workers against Asian employers, is the question of how do you think you represent justice for Asian Americans if you're constantly suing Asian businesses? And that's part of the complexity of what critical race theory gets to. It's also, we also, when we go to court, sue the large corporations that the workers were working for, the manufacturers, the retailers who are often white-owned. And the reality is that in a situation like this, oftentimes the doctrines that address race are insufficient to address these problems. For one, and one reason is that the workforce is almost entirely of color. And so you don't have that baseline of comparison between a better treated element of the workforce and a worse treated one. They're all treated like crap. So that's a limitation in the doctrine. Another issue is that those of us who do this work find that we are so often having to pare down the identities of not only ourselves, but of our clients in order to make a legitimate claim on the courts. So, for example, for these workers, a 2002 decision by the U.S. Supreme Court called Hoffman Plastic Compounds v. NLRB basically opened the door to immigration status being relevant to the damages when you bring a claim for workers' rights violations. So what that did was encourage and push defendants in these cases to seek immigration status discovery. And so what that meant for those of us who were doing these cases is that we found ourselves really speaking less and less about all the richness of what made these workers present and in the courtroom, right? Why they'd come to the country, where they'd come from, that they often left families behind, children they were trying to support because they had no way to do it there, had to come here, all the pain, the risks that involved. All of that became functionally irrelevant as a matter of our strategic choice once we came to court, because the doctrines that existed made them at risk as a result. The second example I want to talk about is in the marriage equality context. Again, not obviously or explicit about race in the same way that Professor Robinson mentioned this morning, but in the recent federal challenge to Proposition 8 under Equal Protection Federal Court, many of you will remember that the whole idea of the open secret that Judge Vaughn is actually gay became a big deal. And it reflects, I think, it was this notion that, oh, he's gay, that's why he made these decisions, not because he was applying the law in some neutral fashion that another judge would have done. And I think it reflects, obviously, a whole host of things that we can talk about later, but what I want to focus on is this notion that oftentimes our community's claims for justice become more legitimate if someone else is also speaking for them. And so I think that is both problematic and also an opportunity for solidarity and collaboration. And so we saw that, my office saw that in our work against Proposition 8 as well. I became a spokesperson in the Chinese community because of my multiple identities. So I am Chinese American, I'm the daughter of immigrants, I'm married to a man, and I have young children. And so as a mother, all of these things sort of made me a good spokesperson for an issue. So the problematic side is, of course, many polls showed that we didn't want to show gay families, that would scare people off and make them vote yes on 8. And at the same time, it didn't matter then that I didn't know how to say anti-miscegenation laws or equal protection or even same-sex couples in Chinese when I started the whole process. I did learn. But I think that what we saw also in the courts, and what other people talk about much more eloquently, I'm sure, later on, is that in the courts, so often our claims to justice are about paring down those identities. That we go to court on claims about equal protection by showing our sameness. Right? The gay couples are just like straight couples, and therefore we should be entitled to the same kinds of protections. And so when our office filed an amicus brief to the California Supreme Court about the Constitution of Proposition 8, we also found ourselves doing that. We really focused on how race claims are similar to, if not identical to, sexual orientation claims. And so in that way we obliterated all the complexities within those communities, including the fact that race and sexual orientation are not mutually exclusive. And so I highlight those limitations to what happens in the courts, not to say that we shouldn't pursue critical race theory in the courts and try to push the doctrine in that direction. I also wanted to give kind of a note of hope to all that, which is that in our work outside of the courtroom, in our work in our communities, with our clients, we absolutely celebrate, expose, and use all of those identities. And so with low-wage workers, we meet over food from different countries. We take out maps and let them talk about where they came from and why they came and everything left behind and everything they were searching for, and they create linkages that way. In the marriage equality context, we march every year in the Chinatown New Year's Parade as a proud, gay, obviously intersectional contingent to make the point that we are part of that community. And so I think that the trick for practitioners is to realize that the limitations in the courts do not have to define the way that we practice, and that our claims to justice and the claims that we believe our communities deserve can be realized through multiple ways, even if even if the court says one way, doesn't mean we limit the way we do all the work. And so I just want to close with one quick anecdote about a judge that I never actually appeared before. So the late Robert Takasugi was interned with his family and about 130,000 other Japanese Americans during World War II. And 60 years later, he was a federal judge, and he invalidated a part of the Patriot Act by refusing to indict a group of Iranian and Iranian Americans who were accused of being terrorists. And what he said is that we cannot obliterate the Constitution in the name of national security. So although another judge may have reached that same conclusion, I think it's impossible to ignore the fact that his own experience with a time in which the courts were not so vigilant had to have informed his way of looking at that particular case. And very early on in my career, Judge Takasugi sent me a note, a congratulatory note about a case. And in it, he said that I was a tribute to our community. And I remember that always as a reminder that the judges we have and the communities from which they come are so important, not only because of the rulings that they make.
It's an honor to be here at UCLA and to be on a panel with my friend Cheryl and to meet Julie and Camille, and especially to think carefully about intersectionality and Kim Crenshaw's essential work. So this panel is intersectionality in the courts, and I want to focus on the criminal courtroom. What's the role that intersectional analysis can play there? And the example that I'll use, a kind of a criminal case, is domestic violence. When we look at that problem in an intersectional way, then what difference would that make in terms of who we prosecute and how much we sentence? And the specific intersection I'll focus on is the intersection of race and class. And so let's start a conversation about two high-profile recent cases of domestic violence. One, the Chris Brown and Rihanna case, and the other, the case in which Governor Patterson of New York is alleged to have tried to get the victim of domestic violence to drop charges. And the men and women who are involved in these cases are all African American. So how should we think about these cases? It turns out, I think, to be an extremely complicated problem. Fortunately, we have the work of a genius to guide us on this issue. Her name is Kimberly Crenshaw, and she wrote this piece called Mapping the Margins, where she focuses on domestic violence, among other issues, and thinks about domestic violence in an intersectional way. So in these cases, gender's been discussed a lot, but it turns out that race actually hasn't been discussed. Either the fact that the victims are African American women or that the accused people are African American men. The gender discussion has been a somewhat predictable response from feminist groups whose membership mainly consists of white women, especially in the Governor Patterson, and it's not appropriate to think of it as his case, although the case is focused on him. The accused person's name is Mr. Johnson. In Mr. Johnson's case, there's been outrage that the governor intervened, and especially the National Organization of Women, which had previously been very supportive of Governor Patterson, has now called for his resignation. Some African American politicians, almost exclusively male politicians, black men politicians, have come to Governor Patterson's defense. So to have this conversation, I'm going to kind of wade through a minefield. So I'll just kind of point out the mines that I'm walking through carefully, tiptoeing through. One is this mine called black male exceptionalism, which is the concern about privileging the experiences of black men when we talk about the criminal justice system. And we ignore the extent that other subordinated groups, especially women of color and Native people and Latino people, are also subordinated. And even this is complicated. It's tricky. African American men do experience a unique level of subordination. We are the most incarcerated group in the history of the world. There's no other group, including women of any color or Latinos or Native, that approaches our level of incarceration. So there is a problem there. But that doesn't mean, unfortunately, it doesn't mean that other groups don't experience extremely high levels of incarceration, because other groups do. In mapping the margins, one of the things that Professor Crenshaw points out is that, and this is another minefield, there's actually a different criminal justice problem with regard to domestic violence and black women. And that's underreporting, under-enforcement, and under-caring. So African American women often don't report instances of violence by their intimate partners for a host of reasons, including concern about the criminal justice system and including distrust of the police, that the police won't care. And unfortunately, that often turns out to be the case. They don't take violence against black women in that context as seriously as they might against white women, for example. And then the undercaring about why that's a problem. And the undercaring is especially painful because it comes from people who should know better, civil rights organizations and feminist groups. The black men who run the civil rights organizations don't seem sufficiently concerned, and neither do the white women who mainly run feminist groups. But some of us are brave. So what's the brave response? Again, the other complicated piece here is that there's no evidence, I think, that black men commit violent crimes against women disproportionately, but there's pretty good evidence that black men disproportionately commit some violent crimes. And why is that? Again, it's tricky. It's something that Professor Crenshaw doesn't shy away from in her Mapping the Margins article. She talks about this problem with regard to violence against women. Some people have said, well, that's just another manifestation of racism. And she, to her credit, acknowledges that it is partly that. Again, black men don't disproportionately commit some violent crimes because they are black. They do it in part because of some of the symptoms of oppression sickness, but unfortunately their victims are often, well, they're always other people, and they're often African American, and too often they're African American women. So how should we feel about all of this? Well, I asked a friend who's a white woman who's a kind of prominent domestic violence scholar, well, what about race in Chris Brown and Rihanna? And she said, well, race wasn't an issue in that case. Now, everything that I've learned in 49 years of living on this planet told me that was wrong. Race is always an issue, and especially when an African American is prosecuted. So I like us to think about how race mattered. It came up subtly, like when Rihanna initially refused to testify. There was, oh, well, is this part of the Don't Be a Snitch movement from hip hop? And there are interesting domestic violence implications there, again, with some African American women being concerned about putting people who, in addition to hurting them, are also members of their family and people who they probably will continue to have a relationship with. So again, kind of interesting, deeper analysis there. Chris Brown, his mother was a victim of domestic violence, so how should we think about that? And also, you know, he's, in addition to a criminal, he's a human being who before this actually seemed like a rather nice young man. So what about that? And quickly with regard to the Governor Patterson case. Again, race more explicitly in that the politicians, the black and Hispanic politicians, had a meeting at Sylvia's where they were going to decide what to do. Sylvia's is a soul food restaurant in Harlem. I didn't say that right because it was the black male and the Hispanic male politicians who got together. And one of the female senators, state senators, pointed out all those people were men. You know, what about us? Well, how should we think about that? And there, the black men and Hispanic male response was that he shouldn't resign. The women weren't consulted about that. Again, the strong critique of him now from the feminist movement, even though before this, the white feminist movement, even though before this he was a strong champion of both women's rights and especially victims of domestic violence. You can't look at the depictions of the accused person, Mr. Johnson in this case, and not see race. He's 6'7", he's very dark-skinned, and he's depicted in the New York Post as a beast. We think of Jennifer Eberhardt's work about how black males are associated with and black women too, actually, with apes. And that's very clearly the way that he's described in this case. He and the woman who he's accused of assaulting were raising a child together. She had a 13-year-old son who he lived with. Again, that's part of the equation as well. So when we think about how this might work in a criminal courtroom, again, among the things we have to think about doing intersectional analysis is collateral consequences. So people on the outside get punished as well, right? People do time on the outside, and that often, when we have a situation where 1 in 3 young black men has a criminal case, that means that lots of women are doing time on the outside as well. But again, some of these women, some of these men are hurting women. What makes a difference to me, kind of in conclusion, in this case, in the Patterson case, is that it wasn't a criminal case in which the governor was allegedly intervening in. It was a protective order. So Mrs. Booker, or Ms. Booker, was afraid of Mr. Johnson, and apparently legitimately so, if we believe her allegations. So at that point, she wasn't trying to have him prosecuted. She wanted him to stay away from her. And that seems an area that both is logical and where the criminal justice system, or at least the civil protective system, really could serve a role. But again, we're more suspicious of that because we don't have this trust of the criminal justice system to appropriately deal with the issues of African Americans, and especially African American men. In closing, Professor Crenshaw actually considers like this multi-dimensional issue, not just in the context of domestic violence, but when she looks at the 2 Live Crew case. There was an obscenity prosecution of that. They'd said some vile, this was a rap group, who said some vile things about women. And some people, including Skip Gates, had said, well, they didn't mean it, it was just kind of funny. And Professor Gates said he laughed when he saw those kind of outrageous statements that they made about women. Professor Crenshaw said, that's not funny. It wasn't funny. It was misogynist. But did that mean that at the same time the prosecution of 2 Live Crew for obscenity wasn't racist? And Professor Crenshaw says, no, that's not what it means. These people had done a vile thing where they offended women, but at the same time, the prosecution of them had race all over it. And that's complicated.
Okay, I want to say thank you to all of our panelists, and I think I want to go back to Professor Harris's point to start us off about intersectionality lost and found. In your comments about Judge Sotomayor, in the moment where she says, I think a wise Latina might have made a better decision, you point out that she's a wise Latina. She's not just a Latina, she's a woman as well. But she gets represented as being a Latina, and she stands in for the race at that moment. I'm wondering to what extent, what you think we might have lost out on about not hearing about the gender-inflected parts of her experience, in addition to her experiences as a Latina. And then to relate it to Professor Butler's comments, I'm wondering, when Rihanna goes on the Barbara Walters show and she represents all domestic violence victims that are women, right? She stands on the praise of all women regardless of race. What are we losing there? What narratives about the specific dynamics of domestic violence in African American communities, perhaps even in Caribbean communities, do we lose out on learning about there? Because that was very much part of the popular culture story about Rihanna, was the fact that she was from the islands and she had a particular way of talking to men, perhaps, and an assertiveness that's a common, culturally associated with black women, but maybe particularly Caribbean women. And then to relate it to Professor Sue's comments, do you experience this struggle in terms of representing the claims of plaintiffs in your case, recognizing this intersectional moment and then stepping back from it for strategic reasons to tell their stories?
As to the question of what got lost, I think that it's both, I think, a powerful move for Sotomayor to be able to represent Latinos, right, and to not be disabled from that because of her gender. But it's also important that one understand that her experience as a Puerto Rican woman was actually an important piece of the story that she never got to tell. In point of fact, what I'm trying to describe is really an interruption of her ability to say anything about that story and about the contributions that those insights might have made in the ways that Julie's references to these studies reflect. So if you actually go back into the essay from which, or to the speech from which that remark is plucked, what she ends up talking about is actually a lot of domestic work. That is, in the course of the speech, she's talking about her experience of culture through domestic work. And I don't mean in the sense of maid. I'm just talking about her references are all embedded in caring, cooking, caring for children, even though she doesn't have any herself. And it's a very gendered story that somehow we never got to hear. Now, I don't want to make this sound as though hearing about Puerto Rican food somehow stands for a contestation of power. That's not what I'm saying. But I'm trying to just say that her own particulars, the particulars of her story were actually pretty much silenced by not so much, I think, the fact that she was able to, or that she was in a position to stand for the race, but that she actually never got to speak about any of that at all. And so I would just say that it would have been, I think, extremely powerful for her to be able to talk about that narrative in a specific kind of way, because it would have made clear some of the dimensions in which she was bringing a particular experience to bear on her understanding of the world. It'll be interesting, I mean, this is just a side point, to think about how going forward with reference to the nominations of future candidates, the lesson of the Sotomayor nomination might be picked up by the Obama administration. And it's concerning, I think, to many of us to think that if this is the way in which the discourse is truncated and cut off, that the answer has to be you have to basically, as Julie would say, pare down your client. You have to essentially pare down the nominees so that they don't have these sort of troublesome attributes, are able to sort of fly below the radar and not engender this kind of opposition. So that's just another point I want to put on the table.
Professor Butler, do you have any thoughts about the Rihanna Chris Brown case in terms of racial specificity and what it might have added to our understanding of domestic violence that was lost as a consequence of her standing in the place of women?
Again, I think an understanding of her as an African-American woman, it was a teachable moment. So if you're a woman and if you're an African-American woman and you're sitting in a car with a man and he starts hitting you, then you should call the police. And it's a shame that that is a contestable proposition. But unfortunately, in part because of the promiscuous use of punishment against African-American men in this country, for many people in the black community, that turns out to be an actual question. And so part of the lesson of this moment is that that's the right thing to do. But the conversation doesn't end there. We have also an African-American man in this place as well. So what's the appropriate result for him? And the book wasn't thrown at him. Some people think that he was under-punished, right? And so that's another issue for us to think about. Or even possibly justice outside of the courtroom. What would a truly intersectional approach to domestic violence look at when we understand that, you know, it's a family issue, it's an issue that affects families. So it's got to be more than just about retribution, right, and deterrence. It's also got to be something to do with African-American families.
I wanted to ask Paul, actually, and I don't know if this is correct, because I don't remember where I saw this, but it's just sort of thinking in taking up your invitation to go beyond the court and thinking about what are the kinds of ways in which this kind of behavior might be addressed. And I wanted to ask whether it was true that at least on one of the award shows that Chris Brown was supposed to appear on, that Jay-Z actually vetoed that. That Jay-Z actually said, no, he can't appear on this show. And I thought that was an interesting move because it was sort of an internal disciplinary act. It was kind of a way of saying, this is not acceptable. He didn't make a public statement about it. He didn't do anything about it. He just said, no, you have to stay home. You can't come here. So was that true? I mean, did that happen?
Again, that certainly was a rumor that Jay-Z kind of indicated disapproval, which, again, if we remember our social norms, so how the community responds has a lot more effect than what the law says. And the law has lost a lot of its legitimacy because of overcriminalization in the African American community. So it was an interesting correspondence between the law and social norms in the African American community.
I thought, perhaps I have a special perspective on this as an African American woman and thinking about some of the stereotypes about black women talking back or Caribbean women talking back. I thought it was an important moment to reflect on the relationship between violence and back talking, and that's a story that has class dimensions. It's not specifically race to get represented as race, but it was an opportunity, if we recognize the intersectionally important moment, it was an opportunity for a kind of dialogue that doesn't happen when Rihanna sits and faces Barbara Walters, with a fuzzy gauzed picture screen over her and talks about her inability to be strong and stand up to him, and her ability to leave this man, her inability to leave this man that she loved. That there was a whole part of the narrative that just got brushed away when she was forced to stand in the place of all women. That seemed very tragic to me. Did you have any thoughts about this?
Well, I would just commit that too. I do think that that reflects a broader issue of how we justify all forms of oppression and exclusion by saying that people sort of ask for it, right? That you deserve it because of all of these things that you encompass and embody. And I think that clearly is true, across all forms of identity, of minority identity. And so obviously, we see that in our work specifically around, we work on domestic violence, but we also, in low-wage workers and everything, that people make choices that make them then, almost make them outside the protections of the law because they've somehow brought it upon themselves.
Well, and the part that it reminded me of, Julie, is when you talked about going after Asian businesses on behalf of Asian Americans. And is that difficult, or is that kind of not a problem?
Well, so it's multi-layered, obviously, as everything else that we've talked about. It definitely has brought attack on our organization from within the Asian American community, which then raises other challenges when we say that we represent the Asian American community in other ways, right? In other issues that we feel are important. I think that it's also just been a challenge when we represent non-Asians in terms of how those clients view our legitimacy, our credibility. We've got to build that. We've got to build to a point where there is trust, right? And then I think, to bring it to sort of the whole how critical race theory helps, as I've said, I think there are limits to what I've seen it do in court, but especially for students, I want to be clear that I don't think that should limit its utility in how we learn to practice. And so, I think that it's difficult only insofar as we identify only racially, right? It's difficult only insofar as we say, well, as an Asian organization, we must be in solidarity with everything that's Asian, and that's clearly not true. And so I think our organization and many of the progressive activists in the Asian American community understand, live intersectional identities in taking progressive positions outside of what maybe the majority Asian American view is.
Okay, I also want to invite people to come up to the microphones if you have questions, and you can join the conversation.
Good morning. Thanks to all of you. Have there been successful arguments in the courts that are intersectional?
There are, I may stand corrected, but I think I know of two reported cases. One, a Ninth Circuit case, Lum versus the University of Hawaii, in which Justice Reinhardt, actually writing for the panel, recognized that Lom was stating as an Asian American woman an intersectional claim. He specifically references that analysis. And I believe there's another opinion that cites Lom. And I can't remember what the circuit is on that one, but it's LAM versus University of Hawaii. She's a Vietnamese American professor at the University of Hawaii who was denied tenure and sued.
And actually, in doing research for the panel, I found a second one, and actually happened to bump into the person who was clerking for Judge Fletcher when the opinion was written, and that also cites to Professor Crenshaw's article, a similar sort of intersectionality kind of claim. I tend to think, too, and this is just my thought about this, that intersectionality has more of an effect than we can chart by the actual citation of the article, because I think judges are actually citing the cases that Professor Crenshaw discusses in her article as opposed to citing the article itself, which you could understand that would be kind of a conservative move that a judge would make instead of citing law review articles to cite the cases. And I thought what Professor Crenshaw did a great job of in her piece was sort of laying out the path that a judge could take who perhaps was afraid of taking a more controversial position, could still make the right decision, still understand the analysis, and reflect it in the course of his decision without perhaps making as clear as a stand. I was wondering if you thought that that actually has repercussions in terms of critical race theory's ability to get the credit that it's due if judges are making these kinds of strategic decisions, or do you think it's necessary? Anyone can.
I guess I would just say, from my own vantage point, it wouldn't matter one whit to me if the article was cited, if the idea got carried forward. So what I think is important, though, is that, as you mentioned, that there has to be some analytical shift, right? And it is glacier sometimes to sort of see that move. But there's no doubt that I think you're right to suggest that the power of the insight transcends the number of times that you see the article cited. It also, I think, transcends the number of times you actually see the word, right? Because I think that to the extent, it's sort of an interesting moment. I mean, one of the ways in which the complexity of race is currently being invoked in public discourse is as a way of dismissing its salience. So, I mean, it's sort of like a paradox, but the more people talk about racial, it's very complicated racially, it's a way of sort of saying, and that's why we can't pay any attention to it. One of the things I think that's particularly important is to recognize that sometimes it's going to take a while for those ideas to actually insinuate themselves. And in part, one of the reasons that that's difficult is that were the ideas to be really taken seriously, it would require a restructuring of the entire apparatus. So it's not the case that, sort of one could easily take up intersectionality or easily take up any of these ideas without actually radically altering the structure of a lot of what we consider to be sort of given anti-discrimination law or any other law, the criminal law, as Paul was talking about.
It does bother me that critical race theory in general and intersectionality in specific doesn't receive the credit that it's due. Although I definitely agree that it has an impact that's often closeted. And I think that's regrettable. I wish that every law faculty felt that it had to have a critical race theorist the same way that it feels it has to have someone who does law and economics, or to have a comparativist. And judges aren't shy about citing law and economics or saying the law and economics word. And I do see why. I understand that they are covering when they talk about crit theory, but I think that that's regrettable.
I just wanted to answer that also by saying I do think that one area in which it's not explicitly cited, but I think that it has had an impact is in the area of education and the value of diversity in education, right? So the recent Supreme Court, the Grutter decision, I think the recognition that diversity it's the salience of race, right? That somehow that matters. And I think Bruder thread a needle in terms of how important it was, but the fact that it is a state compelling interest, the underlying studies of all that, which are not cited in, but are all about, grow out of social studies surveys and others that are very much a part of the way we have made race, and without those kinds of documented surveys, right? People are looking for scientific proof that race matters because the rest of lived experience isn't enough. So those kinds of, I think that scholarship, that survey has been, has definitely had an effect on the development of that important area of law.
Professor Brown?
I just wanted to say that Professor Gear-Rich alluded to Rihanna's status as a black person and as a woman. It's funny because when I think of that case, I really think of her status as a migrant. Because the way that was read on the ground in Barbados was, here is a woman who's supporting an extended family, an entire community. She comes from a poor Barbadian family, whose visa status, she may be a green card holder now, but certainly in the beginning is entirely derivative of Jay-Z's company. He's the person who originally filed for her. And so the thought was, had the picture not been leaked, I heard it said repeatedly by West Indians, what use is Chris Brown to her in jail? What is of use to her is Chris Brown's money, and of use to the broader community. And I mean, it sounds very crass and very strategic, but I heard that said repeatedly. And had the picture not been leaked and the reputational damage not been already done, that she would have been far better served to negotiate some sort of internal arrangement. And I think the comment that Professor Harris made about Jay-Z signaling, in a behind-the-scenes type way that this is inappropriate, to say, here's the potential reputational damage. What is it worth to you to prevent this? And to utilize persons like Jay-Z to force a result that would be more favorable to her, particularly since it's unclear if the police themselves leaked her picture, that they're going to be helpful to her. So I just thought that was the logic I was hearing on the ground, and I just thought I would add that.
I just think it's fascinating, too, because it makes you think more about what I liked about what you said about Jay-Z is I sort of imagined him as this progressive, he has this progressive understanding of domestic violence, and so he stands up in this way that we would want men to stand up. But she's also a commodity for him, right? And so that must have created her relationship, an uncomfortable relationship for her with him in terms of seeking his approval about how this was represented in the press and how it was ultimately handled. Your point about negotiating some sort of private settlement between them was something I hadn't even thought of, but there's this additional layer to it that perhaps gets erased because of class, because we think she's a multi-million-dollar artist, and so she's not, there's no way to think that she's economically vulnerable. But if she's sent back to Barbados, she certainly becomes quite vulnerable again.
The interesting thing about Professor Crenshaw's articles is they look like regular law review articles, but as Professor Harris says, they're subversive. So they're going to take us to some places that we might not want to go. And so when we see those pictures of Rihanna bloody, we want Chris Brown under the jail. That's retribution. But intersectionality might require us to think differently about the appropriate result. So retribution is this idea that people who freely choose to do wrong should be punished. But free choice is complicated by race, right? And by Chris Brown's experience as an African-American man. And so how do we deal with this retributivist instinct at the same time knowing, again, that part of the reason that Chris Brown made the decision that he did is complicated by his own subordination?
Hi. I have a cold. I'll try to try to speak up. I think that it's really important to recognize the intersection with class as well as race and gender in understanding domestic violence. I mean, some of the, we're talking about statistics, some of the statistics I've looked at would find a disproportionately higher rate of domestic violence in African American community, and those differences mostly drop out if you hold for socioeconomic status. And I just wanted to sort of insert that perspective in a forceful way, because I think right now, with the current economic crisis, when you understand the kinds of vulnerability that low-income women have and that low-income women of color have, particularly right now, this is a critical conversation to have, because we're seeing rates, and the rates are increasing dramatically in the current economic crisis. So just a little note, really. The other thing I wanted to say is that the panel that meets here at 1 o'clock includes Andy Smith and some others who are looking at other kinds of community-based alternative responses to domestic violence. So perhaps it's just a plug for some of my colleagues. I think that what has continued to be the case, I think intersectionality analysis has had a tremendous impact in response to domestic violence, but I think what continues to be the case is that the federal response and the state responses have been so focused on the criminal justice system. And the response to criticism such as my own and many others to the negative impact that has and over-incarceration and over-policing in African American communities in particular has been, but that doesn't mean women should suffer, as though your only choices are criminal justice system or nothing at all. And it's that kind of false dichotomy that I think we have to address. That's not really a question, is it?
No, but thank you for your comment.
And with regard to the issue of whether poor black men disproportionately commit domestic violence, I'm dubious, I have to say. Professor Crenshaw's Mapping the Margins article notes that white women, feminists, often privilege domestic violence against white women, but they often frame it in the context of my case is different. I know the normal case is, you think this black man beating up this black woman, but I never thought it would happen to me, the white woman says, but it actually happened to me. And that's probably, Professor Crenshaw implies, not an accurate description of who really commits it. Again, I don't know if we have the appropriate ways to measure domestic violence in middle-income white families and upper-income white families. We certainly couldn't do it by reporting, right, any more than we could do it by reporting for any other group. So I just wouldn't trust that empiricism. But given the ways that we know black men are depicted, and especially poor and young black men, again, without some serious empirical grounding, I'd be reluctant to accept claims that they disproportionately commit that kind of crime.
I guess I wanted to just circle back to the Ricci story for a moment and to bring class back in as well, because I think class was doing an awful lot of work in that story on behalf of the plaintiffs. That is to say that white and its convergence with working class permits Ricci and his fellow plaintiffs to claim a particular kind of deserving position. That is the whole, and interestingly in a way, his invocation of his disability was interesting in that context as well. That is, he became more deserving, right, as a consequence of being perceived as white, working class, and overcoming dyslexia. So I say all that to say that I sort of would underscore and agree that class is an important aspect of the analysis, but also to put it on the table in terms of how it works in conjunction with white racial privilege to sort of create a story about who deserves a remedy.
I just want to pick up on that and talk about, there's a case right now pending in Orange County where it is a group of workers who sued their employer, but basically the lawsuit that's pending is the employer has sued the workers back for defamation because the workers called him a racist. So it's a little scary to think that, especially for civil rights lawyers, if calling someone a racist is an actionable claim, then we're all in trouble. But I think that what happened there was the workers were fired because they had, it's part of the Social Security no match. Their names didn't match the Social Security numbers, so they were fired ostensibly for not having proper documentation status to work. So in part of their campaign against the employer, they called him a racist. And I think what happened there was that the judge didn't like that. And at the end of the day, the judge's conclusion was essentially that, well, the reason why it's defamation is that sometimes becoming racist is a matter of opinion, but in this situation, he clearly was not a racist since he had a legitimate reason to fire them, right? So it's just that there's only two possibilities here. Either he's a racist or he had no reason, and clearly that's creating false dichotomies that then limit the outcomes. And in this, relevant to this panel, I think that is a case in which the judge's perspective on what he's able to see, what he sees as legitimate, what he himself, would imagine if that accusation was made of him, all factor in to a very short opinion that had very little reasoning in it.
Can I ask a question, since this is a panel sponsored by the American Constitution Society, which has had a big impact on the Obama administration. A lot of people who were part of that organization now work in the administration. And are there things you think that we can learn from that example, the success, relative success of the ACS? And by we, I mean crits and people who believe in intersectional analysis. Are there ways that we can be more influential in kind of overt ways?
It's a great question. You got an answer? No, I think that the success of ACS in a very short time in sort of organizing nationally, I think is important. And I think the lesson I would take away from it is why it's important to try to create a structure that has the ability to create certain kinds of outlets at every school. So I think that part of the power of it comes from its engagement with students. And the fact that, but of course, resources, both human as well as others, are required. But I think the lesson I would take away from that is why it's really important to have students in motion.
Well, I love that we're ending things with the students, and I think that's totally right. I imagine the very enthusiastic law clerk who's taken CRT courses handing, Kim Crenshaw's article to a judge and saying, "You got to take a look at this. You really need to think about this." And I think that's one of the ways that's one of the most promising ways, as well as creating the path in terms of existing doctrine to recognize some of the insights that critical race theory generates. But I think we are pretty close to the end of our time. If no one else has any questions, we can just, sure.
Well, I just wanted to pick up the fact that Sotomayor hearings in fifth grade was that they kept pounding her about that one statement, which, once or twice or three times, they could bring it up and she explained herself, but it was like they were putting a barrier down. We want neutral judging. We don't. I just wondered how you reacted to that. I mean, I knew it was pragmatically important, but how did you think about it, the way they were handling her Berkeley speech?
Well, I felt like it was, your image is quite right. They were using it as a club. And it was her intersectional identity as albatross. That's what I was trying to say. That it became a way of actually forcing her to articulate distance from that identity as a way of achieving confirmation. So it was an interesting moment in which her intersectional identity was constantly put before her, in which she had to disavow it. And it was the only mechanism available to confirmation. It was a way in which it set up a dialectic in which she had to claim race neutrality and colorblindness. Right? So it was the use of identity against her that pushed her into that position.
I agree with the content, the substance of what you're saying, but I'm just talking about the frequency. She'd explained it away, and then she explained it away, and she explained it away, and then you just kept pounding her with that.
Go ahead, Julie.
Well, one thing that I think is interesting is that obviously that was a very high-profile situation. It was the first appointment to the Supreme Court of a Latina by our African-American president. But throughout history, the notion that judges of color cannot be neutral has been a theme, right? That judges of color, as few as there are, and women judges there have been attempts to recuse them from cases because it's believed that they cannot be neutral. And that, I think, is very much at the core of how critical race theory makes us look at what neutral is, right? Explodes the myth of straight, white, and male being neutral. But, I can't tell you, obviously, there are specific cases where African American judges who had done some work in civil rights were suddenly unqualified to sit over any civil rights cases, whereas the fact that other judges have never, ever even thought about civil rights their entire lives are somehow qualified to judge on cases. So I think that it's really part of a much larger theme about how we view the judiciary, how we view neutrality. And I think because Justice Sotomayor had this one comment that, her opponents, I think, strategically, smartly picked up on, because that was something that could get a lot of people really upset. But to focus on that only really, it ignores the fact that this has been a problem for changing the judiciary and for, any judges that don't fit the straight white male norm for a very long time.
And I think her repeated explanation serves as a sort of ritual, like this is how we discipline people who speak in this way, and this is how a judge should act, this is what identity should mean. And so you have to continually apologize, and it becomes a ritual that disciplines us all as we watch her struggle in that uncomfortable position.
And just real quickly, the problem isn't so much that she said it, because it's true. The problem is that Obama made her take it back. Because if that's the most you can say, something that's true and not even all that controversial, to be a judge, then not a whole lot of people attending this conference are going to be judges. And that's a bad thing. That's a bad thing.
I think we can take one more, I hope it's a comment, because we're out of time, but I'd love to hear if you have some thoughts you want to share with us.
Just sort of to follow up to that then, and what would be the advice to your students then if you write CRT articles that don't get cited and you say CRT things and that disqualifies you from positions of power, where does that leave you?
My advice is to the students to give Obama hell. Don't take it. Say, the bar has to be a lot higher than that, because it can't possibly be don't say what you think, or don't say even part of what you think. I don't want to give that advice to my students. Now, the people who are looking for a job in teaching, I might give a little bit of advice.
And I would just say, right, some of us are brave. Some of us are brave. Some of us do it anyway. So.
Yeah, I guess I would just point out that there isn't any other option than to struggle against it, right? Because there isn't any position from which one can take that it either goes away or, So it has to be the case that struggling around this is absolutely crucial, not just for her or subsequent nominees, but for the rest of us. Because as I pointed out, it's not like the other side isn't deploying identity. Right? It's not like Clarence Thomas and Alito and others aren't deploying identity. They are. Right? So, the question has to be sort of, obviously you have to pick your battles, but I'm thinking this is one that's worth fighting about, for sure.
I just want to say to students, if you say what you think and then you can't become a professor or a judge, then the civil rights practitioner world will welcome you with open arms.
Thank you to all of our panelists and to ACS and to UCLA.